In a medical malpractice case, during pretrial questioning where I am questioning the doctor who you believe caused you injury, can the doctor turn around in response to one of my questions and say, "I'm not answering that question"? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. The answer is no. The doctor cannot go ahead and say, "I'm not answering that question." Now, there are certain instances where the doctor's attorney, who's present during this pretrial question and answer session known as a deposition. There are instances during questioning where the attorney will make an objection and say, "Counselor, I direct the witness not to answer that question. That's privileged information." So, for example, if I ask the doctor what he spoke to his attorney about, the attorney would have every right to object and say, "Objection, that's privileged information." Or if I ask the doctor something so outrageous, the attorney may turn around and say, "Objection, that's palpably improper. It's got nothing to do with the claims being made. It's got nothing to do with our defenses. You can't ask that question." So now, what if I ask the doctor a question about whether he violated the basic standards of medical care in this particular case? Can the doctor turn around and say, "I don't like your question, I'm not answering it"? The answer is, no, he can't. He has to answer that question. But what if he still doesn't do it? What if his attorney says, "Doctor, answer the question"? He says, "No, I'm not answering the question." So now the attorneys can go ahead and call the court and ask the judge for a ruling in the middle of our question and answer session. And if the judge is available and he agrees to hear this oral argument by telephone, now he's going to compel the doctor to answer that question. But what happens if the doctor still says, "I don't care, I'm not answering that question"? We will either have to bust the deposition, meaning end it right then and there, and now I have to make a formal written request to the judge to now go ahead and ask for sanctions and penalties and fines because the doctor refuses to do something and comply with the judge's legal ruling. Or I can preserve my right, protect this issue, and now continue on and finish up the rest of the questions that I have for the doctor, and then when we're done, I can then make that written request to the judge asking for sanctions and fines and penalties, as well as asking the doctor to come back for another question and answer session. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in the pretrial litigation process in cases involving an accident matter or medical malpractice matter or even a wrongful death matter here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I do this every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.